attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the 7th segment in a multi-part LawCast discussing OTC markets and in particular the different quotation levels and listing criteria for each level. In this series of LawCasts, I have recently been talking about the OTCQB marketplace and quotation criteria. Today, I will discuss the initial disclosure and certification requirements for the OTCQB. All companies are required to post their initial disclosure on the OTC market website and make an initial certification. The initial disclosure includes 1. Confirmation that the company is current in its SEC reporting obligations, that it has filed all reports with the SEC, that all financial statements have been prepared in accordance with US GAAP, and that the auditor opinion is not adverse, disclaimed, or qualified. 2. If it's an international company, the company must certify that it is either subject to the Exchange Act reporting requirements and current in those reports, or that the company is relying on the exemption from reporting found in Rule 12G3-2B, that it is compliant with that exemption, and that it has posted in English using the OTC Disclosure News Service all reports for the last 24 months on their profile page on OTC markets. They must also certify that all financial statements have been prepared in accordance with US GAAP and that the auditor opinion is not adverse, disclaimed, or qualified. Finally, all companies must include a verification that the company profile is current, complete, and accurate. As always, details determine diligence, and all companies are required to maintain a detailed and accurate company profile, initially and going forward. All companies will be required to file an initial and annual certification on the OTC Markets website signed by the CEO and CFO stating that the company's reporting standards, or what the company's reporting standards are, in particular whether they're SEC reporting, bank reporting, or international reporting, and briefly describing the registration status of the company. If the company is an international company and relying on 12G3-2B, that it is current in such obligations, that the company is current in its reporting obligations to its regulator if it's a bank, and that such information is available either on EDGAR or the OTC Markets website, and they must disclose the law firm and or attorneys that assist the company in preparing its annual report or 10K. Also, companies must confirm that the company profile on the OTC Markets website is current and complete. They must identify any third-party providers engaged by the company, its officers, directors, or controlling shareholders during the prior fiscal year and up to the date of the certification to provide investor relations services, public relations services, stock promotion services, or related services. They must confirm that the total shares authorized, outstanding, and in the public float as of a certain date. They must include names and shareholdings of all officers and directors and shareholders that beneficially own 5% or more of the total outstanding shares, including beneficial ownership of entity shareholders. An application to the OTCQB can be delayed or denied if at the OTC market's sole discretion they determine that admission would likely to impair the reputation or integrity of the OTC markets group or be detrimental to the interests of investors. In the next LawCast in this series, I will discuss specific OTCQB quotation requirements related to international issuers. I'm Securities Attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.